For disparate treatment, our prima facie case is set up as follows. The employee is in the protected class. She or he was not hired, terminated, or demoted. The employee met the employer's legitimate expectations. Others not in the protected class were treated more favorably. That differential treatment, as we were talking about. And discrimination is but for factor in the employer's decision. But for age, they would have had their job, no problem. So it's pretty obvious that age was the deciding factor. The employer defense can be, well, there's a bona fide occupational qualification. And while they are the most common and the most consistently applied, it still doesn't mean they can say, well, I just don't like older workers. They have to have a legitimate bona fide reason why an older person is not capable of doing the job. And of course, then the employee can respond by saying that that's just a pretext for getting rid of older workers, period, no matter what. So they can say a bona fide occupational qualifications in place, but it truly has to demonstrate that somebody of a particular age is just not going to be able to do that job, and particularly if that individual was not individually assessed for the KSAs or the abilities that they needed to be able to do that job. In 1986, mandatory retirement was deemed illegal in an amendment to the ADEA, with a very few exceptions. So you can have a mandatory retirement of 65 or above for high-level executives who receive a pension of $44,000 or more. And so obviously that's fairly broad when you think about it, but you can require your senior higher level executives to retire after the age of 65. It's been held up, and firefighters and police officers also may have mandatory retirement ages, and that's fine. Again, because the physical skills to be able to do those jobs, they're very demanding physical jobs, and someone over a certain age may not have the response time or the reaction time to do that job well. It becomes a public safety issue. Employers cannot base employment decisions on age-related stereotypes, because they're stereotypes, because they're generalizations that we're making. They're not about what the individual person can do to be able to do that job. For disparate impact, the employee has to make a prima facie case. There has to be a facially neutral policy, just as you would with the Title VII, and that rule is imposed by the employer, right? So everybody's held to the same standard. There is a differential effect or impact on the older group of workers. Even if there's no intent to discriminate, it still doesn't mean that there isn't discrimination going on. The employer defense is that there should be a reasonable factor other than age that is being addressed here, whether it's economic concerns or seniority-based concerns or things of that nature. So the reasonable factor other than age, the RFOA, basically says that's the defense that the employer can use when there is a claim of age discrimination based on disparate impact. It may include any requirement that does not have an adverse impact on older workers, as well as those factors that do not adversely affect the protected class but are shown to be job-related. There is no RFOA defense in Title VII. It is only unique to the ADEA. One of the biggest concerns when it comes to age discrimination is reductions in force, or RIFs, you'll hear people call it. And it's based in part on salary amounts and salary impact, because when we're doing a reduction in force, we're trying to reduce expenses, and so higher salary workers are more likely to have the impact against them. The discharges, though, need to be based on an objective standard that serves the business. You can't just say, oh, our highest paid workers are going to go and that's it. I mean, you need to have a very clear, precise plan for doing those reductions in force so that you don't get claims of age discrimination leveled at you. ADEA does not prohibit terminations for budgetary reasons, but we want to make sure it's not a pretext for age discrimination. And there are some cases, particularly in your legal cases that you'll have at the end of this chapter, there is a specific case where pretext was given that it was for budgetary reasons, but there was enough factors there that might claim otherwise. So that's up for you to decide whether or not the budgetary reasons are legitimate. So what constitutes an RFOA, or a reasonable factor, other than age? Um, Five major considerations by the EEOC. The factor is related to their stated business purpose, so it has to be essential to their business purpose, that the factor is very well defined and very clearly and accurately applied, that it limits subjective discretion, just saying, well, somebody's 60, so they can't do the job anymore. Well, that's not true. You have to have a very objective way of dealing with it. An employer assess the effect the employment practice has had on older workers, and the degree of harm to the individuals in the group within is assessed as well. So if there's a large degree of harm that's being leveled against the protected group, that's also a consideration here. For reductions in force, generally RFOA defenses are as a standard that's much easier to meet than a business necessity defense under Title VII. So your RFOA is a reasonable factor other than age. You have to be able to prove that there is a reasonable expectation that someone is not able to do a job over a particular age. And then Meacham versus Knowles Atomic Power Lab is sort of that case that established this. The employer burden is to establish that RFOA defense. And so if they can make the argument, then of course it's not necessarily age discrimination. Employer need not meet every factor in the EEOC rule, but it has the burden of persuasion that defense is appropriate to the case. So the employer may not have to necessarily meet all of those standards in that previous slide that we talked about, but they have to be able to show that this is appropriate, and they have to be able to persuade the judge or the jury, on that situation. They may higher paid older workers be offered lower wage terms to avoid layoffs? Absolutely not, according to the statute. You cannot tell somebody, I'm going to pay you less in order for you to be able to keep your job. That's just not going to work. Doesn't mean that the person couldn't voluntarily take a demotion or offer to do it, but they cannot require that of them. With respect to reductions in force, in the event of a reduction in force, or a RIF, age discrimination may be proven when they refuse to allow the discharged or demoted employee to bump others with less seniority, and they should be allowed to. When you have a bona fide seniority system, an older worker can be demoted to a different position. You can't pay them less for a similar position, but they can be demoted to perhaps a lower paying position, and they have the right to bump somebody with less seniority, and that's the way it works. And also when you hire younger workers, when the job becomes available after the employee was discharged. So, for example, you do a reduction in force, and then when you rehire people, you don't rehire the people you laid off. You rehire the people who are significantly younger and who make less money. Under Section 4A3 of the ADEA, you cannot reduce the wage rate of any employee in order to comply with the Act. So if they stay in the same position, you cannot reduce their pay, but you can demote them to a lower position if higher level positions are being removed. The ADA specifically excludes bona fide retirement plans that distinguish based on age, that are not sort of subterfuge or pretext, right, to avoid charges of discrimination. So a bona fide voluntary retirement plan must be truly voluntary, that there should be no criteria that compels people to retire if they don't want to, period. In terms of the same actor defense, when the same actor both hires and fires a worker protected under the ADA, there is a permissible inference that the employee's age was not a motivating factor in the decision. In the Lotus versus Corbis Holdings is a great example of that. So if I hired you and you were over a certain age, and then I fired you, that the assumption is often that obviously age wasn't a factor, because if I hired you over 40 and then I fired you, it was for a reason other than age. There are some extenuating circumstances to this, because it really depends on who actually ordered the termination. Oftentimes, if someone is being told that they have to make a termination, even if they were the ones that hired them, somebody above them is telling them that they have to let them go, there is a sort of an assumption that the other person may have a bias against them, in which case then they would be ordered to terminate them. With respect to retaliation, the ADEA prohibits retaliation in response to an age discrimination complaint filed. So same sort of situation as in the Title VII, where retaliation is a separate claim. The person that is filing the complaint is protected, and any other employee who may have also participated in that claim. So there's punitive damages that can be levied. That's over and above any compensatory damages, that it can be opposed by a court. It's designed in punitive damages, as we've said, to punish the employer, and retaliation claims can get and are eligible for punitive damages.